Hi, and welcome to the Hoffline, your online, hotline, direct line to the women-only attorneys at Hoffheimer Family Law. My name is Katie Carter, and I'm so glad that you're here. I'm a family law attorney with Hoffheimer Family Law, a Virginia-based family law firm that is dedicated to representing women exclusively in divorce, custody, and child support cases. I'm here today with my friend and colleague, Lorna Rhoades, and we're going to talk about some of the things that you need to know before you go. Thank you, Lorna, so much for being here today.
Thank you, Katie. I'm really excited to talk about this important topic with you.
Good. I'm gonna jump right in with the first question, which is basically, I think this is pretty easy, but if you're thinking about leaving, what should you consider before you make that decision?
It's a really important decision, Katie. And I just encourage women to take the time to think through various possibilities before they make the decision to go. The first question I always ask is, are you in physical danger? Because if you are, then of course you can leave. I'm never going to say to a woman, no, you fear for your safety, you must stay in the home. But if it's not a matter of physical danger, then the abuse, if you are experiencing like psychological or emotional abuse, you have to understand that the court may not take that as seriously as I think you and I take it, Katie. Because the court is going to most likely say that, well, you weren't in any physical danger. No one's holding a gun to your head. You're not being physically assaulted. This emotional and psychological abuse that you're experiencing may not rise to the level that you think the court should consider as being abusive. And I say that because if you flee and fleeing or leaving the home does escalate your situation. And obviously, if there's a fear of physical harm, the court's going to be far more understanding of physical violence than it is going to be of emotional or psychological abuse. There is no requirement in Virginia law that you have to leave the home in order to start your separation period. And I think a lot of women don't know that it is even an option to stay in the home and have that still count toward your separation period. It's still a productive use of your time if you're remaining separate in the same house. It's counting towards that 1 year mark for divorce purposes in Virginia. So bear that in mind. Another thing that you're going to have to consider before you decide to leave is whether or not you can afford to pay your way on your own once you leave the marital residence. If you are going to need financial assistance from your spouse, there is no guarantee that that is going to happen when you leave the home. Ideally, you and your spouse have worked out some sort of amicable resolution, at least even temporarily, if you are going to leave the home. But if you haven't been able to do that with your spouse and you're going to need the court's assistance to make your spouse pay, that's not going to happen on a very quick timetable. So you're going to have to plan for you to have a safety net, whether it's friends, family, or you save up money on your own. You have a co-signer to help you get a new apartment. You're going to have to plan for things on your own. And eventually we may get into court, or we will get into court to get you some support set up, but that's not going to happen on a very quick timetable.
Yeah, definitely a good idea to talk to an attorney kind of before you make a huge decision about whether you're going to stay in the home or whether you're going to, physically relocate to a different residence. Like Lorna said, not a requirement that you're living in completely separate physical spaces, though you may prefer to. And safety does always come first. But this is a good point, I think, to have a one-on-one conversation where you talk about the unique concerns that you have, whether you're talking about abuse or whether your concerns are more financial or, kind of whatever's going on there, the decisions that you should be making. And I think this is, for most women, this is something that happens after a period of reflection and kind of considering all of your options. And just as like some more practical pointers, if you're thinking that you're going to physically leave the residence, chances are that that's going to mean that, he has his paychecks direct deposited somewhere else. There's probably not going to be as much money going back and forth as there might have been prior to this kind of obvious permanent physical separation. So go to the doctor, get all your regular checkups done, like anything that has been lingering that you want to look at, make sure you have all those things done, and even do big things like putting new tires on your car or, anything else that you've been kind of putting off. If you're worried about having money in reserves, we've even said to women before, like maybe when you go to the grocery store, get a Visa gift card or an Amazon gift card, kind of collect a few things, a little bit of money here and there, to stock your new house or to get yourself, off on more even footing because there's generally speaking, especially if this is coming abruptly or as a surprise to your current husband, your soon to be ex-husband, things can get ugly fast. So talking to an attorney, making sure that you're making decisions with your end goal in mind, maybe even like if you're going to need a temporary support hearing to get child and spousal support or custody and visitation determined on a more, quick basis, have kind of the wheels in motion before you physically leave the residence because like Lorna said, there can be some delays. So definitely don't, jump first and ask questions later. Ask questions first and then plan your strategy based on the answers that you get so that you know that, kind of the end result is going to be in line with where you wanted to end up.
And also, Katie, if you are, going to leave the home and if the decision is made that it's not going to be in consultation with your spouse, and so if there is this element of surprise or it's not something that they necessarily anticipated, you're gonna have to be aware that the to have an attorney, that's gonna be an additional cost in addition to the cost of living and the other normal expenses that you're gonna have. So you have to consider, how am I gonna pay for my attorney now that it's likely going to be a more contested case, because of the various issues, including the fact that you're leaving the home on a more surprising, timetable.
Yeah.
Um, and sometimes and a lot of times, women come to us, Katie, and they haven't even had a conversation with their spouse about leaving.
Mhm.
And I'm not saying that's appropriate to do in every case, but there are a fair number of cases where there is some sort of amicable separation, at least physical separation between the parties. It doesn't mean that you have to resolve every single issue in your case, but if it's possible for you and your spouse to work out some sort of temporary arrangement, even on some issues, that does keep the tension lower and will ultimately, save you more money because you're not paying an attorney for contested issues to go before the court, or you're paying for fewer issues to go before the court.
Absolutely. Everything that you can resolve between yourselves is ideal. I mean, I think you should always do that in consultation with a lawyer so that you're not waiving something that you might otherwise be entitled to receive. But to the extent that we're able to do anything amicably and, by mutual agreement, that is going to be the best and quickest resolution. Which kind of that leads me to my next question, Lorna, kind of, in the same vein of, making decisions and, some feathers are gonna get ruffled, but we don't want to, make the situation entirely nuclear. If you're leaving, what should you be planning on taking with you?
Yeah, if you're leaving, things that you should be taking are your personal items, the clothes you're gonna need, the things you may need for your children, bottles, clothes for your kids, school stuff, the main essentials. Um, Also, if you are leaving and you have a little bit of time, you want to make sure you take copies of important documents that are in the home, birth certificates, social security cards. If the kids are going with you, I think it's reasonable for you to take those original certified copies with you. Take copies of tax returns, things like that. Now, as far as the furniture and things in the home, what I think is nuclear is if you hire movers and just empty the whole house out and leave your husband with nothing. You want to, not go scorched earth if you over things that aren't required to be scorched earth, I guess. So leave some of the furniture. Take what you need, but don't take everything. If it can be avoided. Same thing with money in joint accounts. In theory, you're entitled to take all of any of an account if your name is on it and you have access to it. But that's a more nuclear approach. If you take half of the money in the account, that's what you would likely get in equitable distribution if you were before a court in the divorce at the end. So take half because that's what you're entitled to receive. If you take more than half, just recognize, is it that important for you to take more than half of what's in a bank account? Sometimes it is. You just have to be fully aware of the effects of doing that. Um, Some other things, you can take your car, you need a mode of transportation. Even if your vehicle is in your spouse's name or your husband's name, it's still something that you as a married person can take with you. It's all part of marital property. So just because it's in his name, like a vehicle, doesn't mean that you can't still drive it if it's your car.
Yeah. Yeah, and you'll need a car, right? You don't
Yeah.
it's kind of, finding the happy medium, like, you don't need to be a martyr and leave at all, but you also probably shouldn't take everything because that's way too scorched earth, way too likely to turn the situation nuclear, and the reason that matters to you is because it can dramatically increase costs and ultimately impact the way the case is going to be resolved. Keep in mind too that just because you have something, like, say, you end up somehow with exclusive possession of the home or you take all the furniture, it doesn't mean it's yours. You take everything in the bank account. That doesn't mean that you are entitled to receive all of it. Sure, you have possession and control of all of it because you were a joint account holder, and so you have access to all the money. But when property is divided in the equitable distribution part of the divorce process, it's the fancy word we use to describe how property is divided in Virginia. If you were to take it all, then there's still the possibility that you would have to pay some of that back to your soon-to-be ex as his portion of a marital account. So just taking it with you, just using it to set up your new house, or even if you stay in the house and he leaves it, it doesn't mean that those items belong solely to you. We haven't resolved anything at this stage. This is, in some ways, I think this is the most difficult part of the entire process because nobody has any, real firm guidelines about what belongs to who at this point, other than just generally what's marital property and how, and wondering really at this stage how we're going to divide it. In most cases, it's going to look something close to 50-50, but we're not a community property state. Virginia doesn't assume automatically 50-50. We kind of assume, I usually say we assume kind of 0-0-0, and then we look at the negative and positive monetary and non-monetary contributions of each party to the marriage. And so it's possible that something other than 50-50 could even ultimately be ordered. So we want to protect you both in the early stages of the separation and also after that through the divorce process. And part of that comes from not having taken or wasted more than you should have. So you want to be protective of yourself, but also conservative. And I think that's often, especially because this is such an emotionally volatile time, it's a good time to bring an attorney in and to be asking those questions to somebody who isn't, going through the turmoil and the upheaval that you are right now, that can help you make a more balanced decision and can help you do that kind of with your end goals in mind, not just what do we need today, but how is this going to resolve and what do we need to make sure that you walk away with what you needed at the end of the process without
Right.
without blowing it up.
Yeah, right, or making you, uh, y making it so the court looks at you if you end up in court and the court says, "Well, you took all of the liquid funds, all the money in the bank account, you took all of the furniture, you took everything." You have to be aware from in consulting with an attorney helps you because you don't our clients don't know what the judges think. They're never in court, and we are, so we know how things are perceived
Mhm.
and seen by the judges here, and it's that type of information that's gonna help you make the best decisions as you're navigating this initial process.
Yeah.
The other thing that I see a lot is when somebody leaves the home and takes their personal property, they often are in a situation where they need to get back into the home to get other items. And I will say that that becomes a more difficult situation because obviously, if your spouse feels that you left and they're feeling that emotional turmoil, they're not necessarily going to be cooperative and work with you to get anything else from the home. So, part of this is understanding when you do leave and you're taking what you have or what you can take, if you don't have another agreement in place where you're gonna come back into the house and get more items, you have to understand this is your one shot to take the main things that you're gonna need. Now, it doesn't mean that when we finally divide everything like you were saying, Katie, that you're only gonna have what you took. No. But I am saying that if it's absolutely essential for you to have medication, food for your baby, things like that, you better take it when you first leave because the chances of your spouse cooperating to let you get back into the house to take other things, I just see it as, it's a lower chance. just because of the situation that's been created. And sometimes that's fine. You just have to have that awareness that you're not it's not going to necessarily be easy for you to get back into the home to get the things that you left behind.
Not necessarily easy or safe, right? I mean, separation is a volatile time for a lot of families, and even if he has never hit you or been physically violent towards you before, I'm not saying that he certainly is, right? I mean, I don't know this man, this is general advice, but I do think this is a dangerous period for many women, and you would do well to, keep that in mind. Take what you need, but don't expect there to be a lot of coming and going, and if there is, I think that increases the likelihood that, something's gonna happen. So just be mindful and be careful. And if you're, at all questioning, your safety, take steps to protect yourself and protect your children, and even if that includes protective order. But also, if you take what you need now and you don't have to keep going back and forth, that can be, a majorly protective decision as well.
Right, or come up with alternatives. Go buy replacement furniture, go buy replacement clothes. I mean, it's not ideal, but we live in a world where we see the, alternatives and the costs of those, and so you're pointing out safety, and I'm pointing out just it's you would maybe have to pay an attorney, and it's not gonna be quick, and it's going to, maybe not the juice may not be worth the squeeze for you to get that dresser or bed set that you left. Maybe you just find a used set or buy a new one and call it a day, because again, the consequences of or the fallout just can often be unexpected, and you really need to consult with an attorney for you to get the full accurate picture so you understand, oh, it's not that my attorney's not on my side, she is just trying to tell me what the cost is and the likelihood of success of my position.
Yeah, yeah. Well, and let's talk a little bit more about the kid. You mentioned taking the kids with you, and it's a big question that I usually get from women that are in the early planning stages of a separation. Can you take the kids when you go? Should you take the kids? And then what does that look like?
Yeah, I mean, you can absolutely take your children with you. When there is no court order, both parents have equal access and rights to the children. So, just like I take my kids to school every day, I can take my kids to my new apartment. Nobody is going to say you're not allowed to do that. But likewise, your spouse also has that ability. So if you drop the children off at daycare, he could show up and pick them up early from school and bring them back to the marital residence, even though you've taken them to your new apartment.
Mhm.
If you are, in general, my advice is take the children with you, especially if you are looking to maintain or end up with a primary custody decision in your case, or even a shared custody arrangement. You want to establish that you're going to have a home for your children and that it is an appropriate place for them.
Mhm.
Um, my general advice is you don't withhold the children from your spouse unless there's clear indications that your spouse will not return them, that your spouse won't send them to school, that there's a real safety issue there. Otherwise, you're taking a huge risk by withholding the children.
Mhm.
And it also could lead to a further escalation in your case by your spouse filing an expedited motion for custody, claiming that his wife, fled with the children in the middle of the night. He hasn't seen his children for days. He doesn't know where they are. That is a more nuclear approach to your case, and sometimes it's appropriate, but it's in a very limited set of circumstances where that kind of approach is justified. So it can be really scary thinking like, how are we going to navigate this? What are we going to do? And it does require, I think, you do better off when you have a level-headed person like your attorney walking you through these types of questions day to day, moment to moment. How do you respond if he's asking to see the kids? Your attorney can help you draft responses, advise you on how to communicate so that you are perceived as a level-headed, um, you know, eh, looking out for your kids in their best interest and not withholding them from the father unless, there's some real safety issues there.
Yeah, I don't think it gets harder than this.
Yeah.
Than than having absolutely no framework for how the assets are going to be divided, for how custody should be shared. Like, you have no framework at all right now, and it just doesn't get any harder. So even though I think that the answers here in some ways are kind of as clear as mud, like, you don't want to leave the kids with dad, but you don't want to withhold the kids. But dad can then keep them at his house, and he can deny parenting time to you. So then, what do you do? And everybody just it ends up being it can be a very reactive cycle that
Yeah.
can amplify tensions and make things a lot more difficult, which is why, again, I think a consultation with a lawyer, getting the wheels in motion kind of before you separate, before either you or he leaves the home, so that you aren't in this period of limbo. To the extent that custody and visitation can be resolved amicably, whether you have a temporary agreement or whether you enter into something that's intended to be a little more long lasting, just to give everybody the clarity of expectations, like knowing, you know, he has the kids right now. He's going to drop them off at school. I'm going to pick them up. I'm going to see them this weekend. So everybody, I always say an agreement is like the foundation of a house. Like, you have to be able to build your expectations upon that foundation, and everybody has to go into their separation, their divorce, their happily ever after, knowing what to expect. The unknown stresses everyone out. The unknown makes everyone freak out and makes everyone do things that are more nuclear. So, while you should be taking the kids, you should also be, to the extent that is safe and possible, in near constant communication, and having conversations about what parenting time is going to look like. And of course, if again we're talking about an abusive person, that puts you in kind of a separate category, but that's also something that you should be talking about, that should be part of a larger overall case strategy, and not an emotional reaction made in the heat of the moment. We have to have an end goal in mind, and then we have to be making decisions that are in alignment with that end goal, so that you don't end up in a worse situation rather than a better one.
Right. And I would always rather be in the position where my client has behaved or made decisions that reflect that sort of level-headedness and that end goal in mind, and then give the husband the opportunity to reciprocate and also act rationally and within the children's best interest.
Yeah.
Given that opportunity, though, it's out of our control how he responds.
Yeah.
If he responds poorly, we've at least set the stage so that if we do go to court in response to his poor reactions, we are now in a position where we can show the court we've done everything right in the way the court would expect us to, and it strengthens our case in that situation, to show that dad is the one who acted emotionally, who's acting erratically, who's not allowing mom to talk to the kids, who's not taking them to school.
Yeah.
So I do often say that the court is a reactive mechanism and not a proactive. And moms often come in and they say, I know what kind of person he is. I know he can't do this. I know he's going to fail. I know him. And I say, well, the court doesn't know him. So
Or
we
needs to see it happen.
Where needs to actually see it. It's and even if there's evidence in the past that he hasn't done what he's supposed to do, the court's gonna look at it from, well, that was when you guys were a married couple, and
Mhm.
that's just how you guys structured the parenting roles. That mom was just allowed to do that was her role. Mom did everything. Dad didn't do everything or anything because that's just that was their arrangement. If
Mhm.
you could tell me you only did everything because he refused to, and then I can say I believe you, but the court is gonna wanna see him fail
Mhm.
in the context of you guys being separated. In order for the court to see the true as you have known it, it's just you have to be patient and let that process play out. So that's all to say is, like, as we're going through this step by step, we want to set the stage so that if it fails, we want it to be very clear that it was because of dad failing, not because of mom not doing what she's expected to
Yeah.
do. And that can be really, really hard, um, to kinda make your kids the guinea pigs,
Yes.
but, we have to have safety plans, just talking through what could happen, what to expect, just so you know, all right, worst case scenario, dad gets the kids and something happens to the boys, or what we would do in response to that. Okay. Because I can think that can also help the emotional fear of the unknown, become a little less unknown, and can help calm your emotions down. So
Yeah.
That's our strategy a lot of the time is to just give dad an opportunity to fail,
Yeah.
or not fail, but he has to have an opportunity.
Yeah. Yeah. In some ways, it's such unsatisfying device. I'm glad you used the word guinea pig because it's
Yeah.
that's what I think. I hate to think of our children, and Lorna and I are both mothers, so keep in mind that, we have children of our own. We see this, not just lawyers, but as moms as well, and it's terribly unsatisfying advice to say, "Well, we have to give him a chance to screw up." But I don't necessarily mean that he would screw up in terms of, like, the health or safety, but if he's the one acting irrationally, if he's the one who's, shoving a camera in your face at every visitation exchange, if he's the one who's complaining, he's sending, text message after text message, and they just are more and more abusive and make less and less sense. Like, that's all good evidence. And I know, like, it can require the patience of a saint to not take that bait. But to the extent that you can maintain calm and cool and collected, you can gray rock him or whatever method you want to use so that you don't engage in this kind of back to back, tit for tat kind of warfare that so many separating couples kind of, fall into these, terrible patterns. It's going to be really, really helpful for you. So, coming up with a strategy, having end goals in mind, and then making every decision, making sure every exchange, whether we're talking about text messages or emails or phone calls, because, Virginia's a single party consent state. He could theoretically be recording those too, even if he's not telling you, whether he's shoving your phone in your face at visitation exchanges, just staying calm so that you can, because it's not a question about how you appear to him. It's a question about how that recording or those text messages or that email is going to play out in court. And we want you to look like you are not the problem. And he obviously is. And if he's giving you that opportunity, don't don't fall to his level because then it ends up being something that nobody wants to use because everybody looks terrible in in that particular recording. So, give us the evidence that we need by not engaging in those behaviors and being able to walk away without making the situation worse. I think it's going to save you money. It's going to save time and ultimately, resolve things in your favor.
Mhm. Yeah, absolutely, and it's counterintuitive, and, in the moment, I really do think so, and that's why having, the support and instructions from your attorney can
Yeah.
we dial back the emotions because we can tell you, "Yeah, this is the consequences of his behavior," or, "This is our strategy if this behavior from dad continues," right? If he's
Yeah.
late you exchanges, if he doesn't tell you where the kids are, if your kids come back and say, "We never ate," or you can see a pattern of grades, that they're not doing their schoolwork, all of that can be evidence down the road. Um,
Yeah.
but if you just took this position of, I'm not sharing the children, I'm not sharing any information with dad, I'm not going to facilitate contact, I'm not going to send them with the kids on parenting time with dad with their backpacks, like too bad, too sad. That type of behavior isn't going to look good, I don't think, with the judges, and it's not going to serve your end goal. Um, so, it's just very, very important that you have those conversations with your counsel and possibly also a mental health professional to help you navigate those feelings that you experience when you have to interact with him.
Absolutely. This is such great advice, Lorna. Thank you so much for joining me today. Thank you, everyone, for listening in. I hope this was really helpful. If you're considering separating, whether you're hoping to stay behind, separate under the same roof, or whether you're hoping to move to a separate physical space, these are all things that you should be considering. You should also check out our website at hoflaw.com. That's HOFLAW.com. We have 4 free books, a ton of free articles, blogs. We have a divorce and a custody seminar, and just a ton of resources out there to answer almost any question that you have about Virginia family law. But thank you so much to everyone for tuning in, and thank you again, Lorna, for being here today.